Thank you, Greg, and thank you, Senator Zito, for everything you're doing for this bill. We just had a last-minute discussion, Don Kilmer and myself, and we're going to stagger this because of the way things are set up here. So it's my honor and my pleasure to be here today to help explain this bill and why it's important to the citizens of Idaho. I want to give you just a quick background. I know you don't want to know all about me, but I want you to know where I'm coming from. I was the first elected woman attorney in my county in Oregon. I am from Idaho. I graduated from a small North Idaho high school, and I'm a graduate of the University of Idaho School of Law, but my career took me to Oregon first, and that's where I spent the first half of it in criminal law. I've been on the crime scene when firearms have been used in self-defense. I know how important it is to be able to defend ourselves. And after I left office, I've been involved in a number of different Second Amendment issues. It has been, again, my honor and my privilege to work with the folks at the Idaho Second Amendment Alliance to try to keep the stronghold that we have in this state that keeps us at the forefront of fighting for the Second Amendment, but also for what the Idaho Constitution protects. So we've been involved in a number of bills that have been have gone through and become law with the Idaho Second Amendment Alliance, including constitutional carry. We've worked on Stand Your Ground, the Castle Doctrine, the Enhanced Concealed Carry Law. All of those things have been pushed and promoted by the Idaho Second Amendment Alliance, and it's been my honor to help with that. In private practice, I assist folks in Idaho with the restoration of gun rights. And we also have some issues there. One case that's before the Idaho Supreme Court right now is this Gutierrez matter. And I'm not going to go into great depth. I just want to point out that there are a number of different ways that we are affected by how the courts are interpreting our laws and the Second Amendment at the federal level that are affecting the citizens of Idaho. And Don and I are working together on a case in Sandpoint right now where the government has essentially blocked Idaho citizens from bringing their firearms to an event. So we're challenging that. And I'm going to introduce Don because he's not up here right now. Do you want to stand up at least? Don Kilmer. He's my friend and my colleague, and he has been on the forefront of fighting for gun rights in the state of California. So he knows what this is all about. He's been in the courts and he's been making challenges, and I'm sure he'll have more things to say about himself, but I just want you to know that he's a constitutional law professor, and he's going to help explain this bill as well, okay? So the dangers that we faced, Senator Zito touched on this. There are a number of dangers. She said 20 bills. There will probably be more. And the things that are being proposed are outlandish. They want us to have psychological evaluations before we can possess a firearm. You know, there's a whole host of reasons that the people of Idaho are concerned and have valid reason to be concerned about protecting our gun rights. You know, magazines and firearms that we use every day for self-defense, maybe even for hunting, are going to be deemed illegal, banned, if they get their way in Congress, okay? And we don't want that to happen. So these things here, I put on the next slide, they fly in the face of who we are as Idahoans. This is not our culture. We stand up for ourselves. We take responsibility for ourselves in this state. We protect ourselves. We are responsible citizens. We're not crazy people with guns, as other folks might like to proclaim. And this is our culture. So we are very different from perhaps the culture in San Francisco or in New York City. And we have a right and we have the power to protect that. So our Constitution spells that out. You know, and you'll look at this highlighted section here. No law shall impose licensure, registration, or special taxation on the ownership or possession of firearms or ammunition, nor shall any law permit the confiscation of firearms except those actually used in the commission of a felony. This is our Constitution. These are our beliefs. And what we're striving to do with this bill is we're going to protect that. So, you know, one of the things that has come up over and over again as we've proposed this change to our laws is we've heard from a number of people, we already have that. We don't don't need House Bill 300. It does nothing for us. What we have is good enough. And I have said over and over again, it's not good enough. What other states are doing around the country right now is not what we are proposing. What other states are doing now is what Idaho did 10 years ago. Okay? We're ahead of the game. We're voted #1 in the country for gun rights for a reason. Years ago, when I first started working with the Idaho Second Amendment Alliance, we were 32 in the nation for gun rights. So we've been doing our hard work to protect this state, and we don't want that to stop, all right? So we did pass these 2 statutes that I have up on the screen, one in 2010, one in 2014, in an attempt to stay ahead of the game, all right? What is the law that was first passed in the state of Idaho that other states are doing now? It's a sanctuary bill. It's a sanctuary state-type statute. If you make a firearm in the state of Idaho and you keep it in the state of Idaho and you stamp it made in Idaho, what the state of Idaho tried to say with this law is we don't have to comply with the federal government, okay? So Greg, in a recent email, used the phrase, we're lifting the finger at the federal government. And that's pretty much what this law said. We're not going to obey you. That's not what we do here. We're not going to obey it. The second law that was passed in Idaho in 2014 was a punishment-type statute. So now the legislature affirmatively came forward and said, we are not going to use Idahoans' taxpayer money to enforce illegal gun laws. So if you try to, if you're a state official, if you're someone who has the power to tell other people what to do in your job, and you tell them they have to assist with what we see as an unconstitutional law against our Second Amendment rights, or our rights as Idaho citizens, then we're going to fine you. And if you do it again, you're going to be convicted of a crime. Okay? So that's what the second statute does. These are acts of defiance, and we are not trying to repeal them. We are trying to add to them, again, to make sure that Idaho stays the strongest state in the country for gun rights. Now, given what I just said about those laws, do you think the courts had a problem with that? Okay, one of the first cases that came out was Montana shooting sports case. This was about a Montana citizen, and Montana had passed a very similar sanctuary law, very similar to what Idaho has on the books. And this person had developed a .22 rifle. Okay, we're not talking about a machine gun or anything super scary to anybody. It's a .22 rifle called the Buckaroo. And he wants to sell this without complying with the Gun Control Act, being licensed. And when people buy it from him, he doesn't want to turn their name into the FBI for a background check. Okay, so he asked the court, is this law going to protect me? This guy's smart, okay? He doesn't want to just, he sees the issue here. He sees it coming down the pipes, and he wants to make sure that he's going to be okay. The Ninth Circuit, which, by the way, for those of you who may not know, that's the circuit that we sit in. The Ninth Circuit said, we're not going to help you. This law violates the Commerce Clause of the United States Constitution because if you're making guns, you're going to affect the market for guns, and therefore Congress has the power and the authority to regulate that. So we're going to uphold the federal government here. You guys are out of luck. This case went to the Supreme Court on a petition. The court said, we're not going to hear it. Okay, so they didn't come to our help. Now, that was years ago, and Don's going to have some stuff to say about that, I'm sure. There was another case on another similar law, United States versus Kettler and Cox. One or both of these guys were veterans. They were making suppressors. They were trying not to comply with the federal gun laws. Again, very similar to what happened in Montana, except these guys got indicted and prosecuted and convicted in federal court for following what their state said that they could do. All right? Again, nobody came to their help. All right? So, 10th Circuit, we're not going to help you. United States Supreme Court, this isn't interesting enough for us to care. Okay? So what about Idaho? I have been involved personally as an attorney, helping people who have followed Idaho's law that's on the books. The federal government is going after people. Don't think that you can make a suppressor in Idaho, not register it, and pay the tax, and sell them or whatever you want to do with them, and just deny federal law. It's not going to work. they will come after you. So this is where I reached out to Don, and we started discussions about what can we do that's better? How can we actually create something, some kind of law that is actually going to provide some kind of protection or be interesting enough to the United States Supreme Court that we could possibly successfully challenge the federal government. We want overlap, not gaps, has become our motto. And so we're not saying we want to throw away what we have. We just want to bolster it. We want more. And that's how we came up with House Bill 300. I think you took a slide out, Don. So the House bill that is presented now to the legislature, in which Senator Zito and others are fighting and advocating for a hearing on this law, is something that we absolutely believe will be helpful, will help protect our rights in this state. We've dubbed it, it's technically called the Small Arms Protection Act, because we have specified the things that are important to Idahoans and that we don't believe the federal government has the right to take away from us. But we've started calling it the Idaho Constitution Protection Act. And the reason is that this is bigger than the Second Amendment. This is about protecting our way of life in the state of Idaho. And now I want to make sure there's plenty of time for Don to explain this. So I'm going to step off stage and let you hear from him.
Thank you for having me. Just to be clear, we kind of went by the slide that introduced me a little fast, just so I don't get in trouble with the Idaho State Bar. I'm not an admitted lawyer in Idaho yet. My application is pending. Hopefully I'll be approved soon, and then I can speak to you as an Idaho lawyer. So what I'm telling you today is based on United States constitutional law and my understanding under Alex's supervision of Idaho law. So she's my supervising attorney right now. We've been here before, folks. Federal overreach and federal attempt to impose its values on the states and the people is a contest or a conflict that is as old as the country. Okay, back in the 1790s, the Aliens and Sedition Act threatened our First Amendment rights to freedom of speech and freedom of the press. People were thrown in prison because they criticized their government during the John Adams administration. This sparked a huge controversy in the election of 1800. As we know, John Adams had only served one term. Thomas Jefferson was challenging him. They used to be friends. The battle actually caused a rift in their friendship that lasted almost 20 years. Thomas Jefferson's primary platform was that the Aliens and Sedition Act was a violation of the Constitution. And in fact, once Thomas Jefferson won, he pardoned everybody who was convicted under the Aliens and Seditions Act and worked to repeal it. But while that was going on, there was a controversy and a debate that was taking place, much as is taking place here in Idaho today. And that is, can we nullify federal law, or can we interpose our state constitutions and our state laws between the Constitution, the federal government, and ourselves? We also have before I get to that, the difference between interposition and nullification, we also have the example of the Fugitive Slave Act that was passed by our Congress in the 1840s. This allowed for the recapture across state lines of runaway slaves, people who had liberated themselves from bondage. The most famous U.S. Supreme Court case on that was Prigg versus Pennsylvania. In Prigg versus Pennsylvania, there was basically a slave bounty hunter who traveled from Maryland to the state of Pennsylvania to try and recapture a woman who had actually been liberated by her previous owner, a man who then died, and then, according to the laws of the state of Maryland, his property in this poor woman had passed to his wife, and she wanted the slave returned. So this bounty hunter from Maryland travels into Pennsylvania to recapture this woman and bring her back to bondage in Maryland. He was stopped. He was convicted in a Pennsylvania court of assault and battery and kidnapping. The Pennsylvania Supreme Court upheld his conviction, so he was going to go to prison for that. He appealed to the U.S. Supreme Court. The U.S. Supreme Court overturned the conviction based on the supremacy clause of the United States Constitution. The Fugitive Slave Act overruled Pennsylvania's common law criminal statutes with regard to assault and kidnapping. However, the U.S. Supreme Court in Prigg versus Pennsylvania included some dicta, or a footnote saying that, however, states are not compelled to assist in the compliance or the enforcement of federal laws. Well, there were a lot of people in Congress who were not happy with that. So in the 1850s, there was a new and improved Fugitive Slave Act that was passed along with the Missouri Compromise. The South was leveraging, at that time, its numerical advantage in Congress, and there was bitter opposition over this. And they were attempting to extend slavery into the territories and the other states in the West. Of course, we all know that that conflict eventually resulted in the Civil War.
There we go.
Next one, please. But the election of Abraham Lincoln and the ensuing Civil War tends to kind of overshadow or obscure some of the things that the states did to defy or at least nullify or interpose themselves between the federal Leviathan and the rights of the people. For example, once the new and improved Fugitive Slave Act was passed, Vermont passed something called the Habeas Corpus Law. It was a law that the legislature in Vermont passed that authorized the attorneys, including the Attorney General of the state of Vermont, to protect, defend, and procure the discharge of any person arrested or claimed as a fugitive slave. The law was so successful in thwarting the ability to recover fugitive slaves under the Fugitive Slave Act that President Fillmore at that time actually considered sending federal troops into Vermont. He was talked out of it by his cabinet. In Wisconsin, the state judges in that state, all the way up to the Wisconsin Supreme Court, started issuing writs of habeas corpus to anybody who was held under the Fugitive Slave Act. In other words, it was a direct confrontation between the laws of the state of Wisconsin and the federal laws that said, that compelled the release of people who were being held under the Fugitive Slave Act. Another case from Wisconsin actually wound its way up to the U.S. Supreme Court, and the U.S. Supreme Court, to its shame, overturned it. But that did not stop the Wisconsin judges from continuing to free prisoners who'd been captured under this law. An interesting thing happened in the state of Massachusetts, and that was where people who were charged with the crime of obstructing the Fugitive Slave Act by helping slaves escape or by thwarting the efforts of federal officers and bounty hunters were put on trial under federal law for obstructing federal law. There was just one problem. Of course, we have a right to a jury trial in this country. So what happened? Lawyers got together in the state of Massachusetts and started putting on cases of jury nullification, where juries were basically told to ignore the federal law, uphold the state law of the state of Massachusetts, and do not convict these people who were helping people in the Underground Railroad to make their way north to freedom. So what does SB 300 do? It relies on the mechanism of interposition, what Vermont and Wisconsin and Massachusetts were doing prior to the Civil War. Slight history lesson. If you want to go back and try and understand this, go back and read the Kentucky Resolution, which we all believe was authored by Thomas Jefferson at the time. That was a document that advocated nullification of federal law, a theory that we now know cannot work. The Montana shooting sports case tells us that. Okay? But James Madison, some people consider the author of the Constitution, and who we know was responsible for getting ratification of all of our amendments in the Bill of Rights, actually had proposed the Virginia Resolution, and where he advanced the theory of interposition. The idea that a state, through its laws, through its court systems, and through its own constitution, could act as a wall of separation or as a barrier between what the federal government was trying to do and the rights of the people. Nullification promotes confrontation between executive branch agencies. But interposition promotes confrontation in the judiciary with constitutionally limited powers of the federal government and the retained powers of the states beating each other up. SB 300 interposes the Idaho Constitution between us and the federal Leviathan. It's not just an act of defiance. It is the state of Idaho exercising its power to protect us.
Hey, Don,
And
it's HB 300, by the way.
what do I keep saying?
It should be a Senate bill, but it's HB 300.
Well, pardon me, folks. My mistake. That should be HB. Also, HB 300 gives us the moral high ground. The Ninth Amendment says that even if a right is stated in the Constitution, it does not affect the rights that are retained by us, the people. Okay. The 10th Amendment says that any powers not delegated to the United States by the states, nor prohibited to the states, are reserved to the states. Folks, this is the power that the state of Idaho has to say, look, we have a lifestyle, we have a way of life in this state in which we protect the rights of our citizens stronger than the U.S. Constitution does. Imagine a thought experiment for a second. Suppose tomorrow the Supreme Court gets packed with 15 justices. Joe Biden gets to appoint 6 more. And they decide to reconsider Heller. And they decide that Heller doesn't mean what they said it means. And that now you have to be a member of the militia or the member of the state militia in order to exercise your Second Amendment rights. Does that mean that your right to keep and bear arms under the Idaho Constitution evaporates? No, you still have your rights under the Idaho Constitution. And what we hope to do with HB 300 is strengthen that right and basically provide an extra argument to those people who will protect our rights, whether they're private litigators like myself or the Attorney General of our state, to give them an extra argument that says, look, this is a line. We're not defying federal government. We're simply saying that our Constitution is stronger than what you have. The language provisions of, again, ignore the mistake, HB 300 is that the provisions of this section are authorized pursuant to the authority of the United States Constitution, the state of Idaho, the Constitution of Idaho, and the Second, Fifth, Ninth, 10th, and 14th Amendments to the United States Constitution. Our authority for that are 2 U.S. Supreme Court cases that have already ruled in our favor, United States versus Lopez and Prince versus United States. Specifically, the state of Idaho reserves to itself the power to protect the fundamental individual rights of citizens and residents to a degree greater than protected by the United States Constitution, and to do so in such a manner that this state and its citizens believe is necessary and proper to their safety and happiness. There are plenty of other United States Supreme Court cases directly on point. For example, some states protect your right to be free from unreasonable search and seizure to a greater extent than the Fourth Amendment to the United States Constitution. Some states protect your right to your property under eminent domain taking laws to an extent greater than the U.S. Constitution. We all know, if we remember the case Kello versus, I can't remember the name of the case, but it's the Kello case. Remember the poor woman who lost her home in Connecticut to eminent domain laws because the city wanted to build a shopping center. Thank you. We got a lawyer up here. We've got to protect the shopping center. Her argument was, you can take my property for public use, but you can't take my property to give it to somebody else to build a shopping center. Well, she lost in the U.S. Supreme Court. The U.S. Supreme Court said, look, the Fifth Amendment only protects us taking your property so far. Immediately upon that happening, almost, I believe, the vast majority of states in this country passed laws saying, no, your right to your property under eminent domain laws is protected more than in Kello versus New London, I think was the case. HB 300 also tells us that what is protected and what we consider to be protected items under the Second Amendment, and that includes that we won't tolerate any regulation, taxes, license, permit, or fees. It also reminds everybody that we depend upon our state legislature, people like Senator Zito, to decide what is appropriate for Idaho culture with regard to gun regulation. Contrary to popular belief, Idaho has some pretty strict gun laws, okay? If you use a gun to commit a crime or you use a gun to threaten somebody, my guess is you're going to do hard time in this state. okay? So we balance responsibility with the freedom in this state. I keep saying we because I'm a new resident of Idaho. I've only been living here about a year and a half. Yes, I'm a refugee from California. I hope to prove my worth to you and be welcomed into your community by helping Alex with this work. HB 300 also empowers our Attorney General to protect our rights, and not just challenge the law affirmatively in the court, but to do what he can to help people who are in trouble if they're charged with federal crimes in this court. This law can be broadly interpreted to mean just that. It also allows for a challenge to be taken in Idaho court or in federal court to the provisions of any federal law that infringes on our rights as defined by Idaho statute and the Idaho Constitution. And it also ensures, it builds in a feedback mechanism to make sure that the people's representative, our legislators and people like Senator Zito can maintain oversight over our Attorney General. If we have an Attorney General who decides, like the Attorney General in the state of California did, that he just wasn't going to defend the defense of marriage law in California, and therefore the law was going to be not going to have be represented in federal court by a representative of the state of California. So what happens if your Attorney General says, I'm not going to defend your law in federal court? This empowers a state legislature to be substituted in of our Attorney General doing the work, and then for that legislator to hire a lawyer and to make sure that our rights get vigorously defended. So the whole point here, folks, is that the current laws that we have are a healthy, even moral defiance of the law. Okay, I applaud you for that. But we can do something greater here. We can say that the Idaho Constitution is special. And in this area, it's stronger than the United States Constitution. And we're going to use all the state resources we have to protect our way of life in this state. And with that, I appreciate your indulgences and your time. Thank you very much.
All of us need to go. Okay, so what we want to do now is we want to do a question and answer. I send an email out to all of the senators and representatives that we would be here today, inviting all of them to come. Representative Nichols is here, so thank you for that. Am I missing anybody? Is there anybody else? Am I not seeing anybody? But anyway, because we want to be fully transparent. We want every question that anybody may have about this bill, we want them answered. We want everybody to know what it is that we're trying to accomplish, why it was written the way it was written. We want full understanding of everything that we've got going here. So I'm sorry that they're not here. I made the offer that if someone wanted to email or message me questions, we would ask them. I haven't gotten anything. We've been watching the Facebook Live to see if there was anything on there. So right now, if any of you have any questions, feel free to ask them. We've got the experts here to answer them. So questions? Yes?
Where is the bill right now?
So I can answer that one. So right now, the bill is a House bill. It has had a print hearing in the House State Affairs Committee. It will not advance farther. Its next step would be to have a full committee hearing in the House State Affairs. If the committee deemed it worthy, then it would go on to the House floor for debate and a vote. If it were to be advanced from the House floor, it would go to the Senate to have a Senate hearing in the Senate State Affairs Committee, where it would be advanced to the Senate floor from there. If it passed there, then it would be advanced to the governor's desk for either a signature or a veto. So right now, it's just a bill. Yes?
So on that note, has there been any forward movement with either of the chairmen from
I have not heard that from either of the chairmen of the committees. I am happy to report that Senator Winder has set up a meeting with several senators that he has chosen and invited, and I'm going to bring the team that you see here today to that meeting to ask and answer questions. They've blocked out a 30-minute time section for us to meet, for them to,
When is that meeting?
the 7th, I think, at 2 o'clock, I think. So, yes.
Do you have any impression, Senator Zito, as to what the governor's take on this might be, or our Attorney General? Like, do you have any feeling if there would be for or against this?
Senator Zito, make sure, you might have to repeat the question too, just in case people watching can't hear.
Okay, so the question was, do I have any idea what the opinion of the governor or the attorney general is? I haven't heard a word from either one of them. The governor has been, I don't know what he thinks. I haven't heard anything, so, yes.
Senator Zito, first I want to thank you very much. The Capital Clarity meetings and all of you, those handful of you who have been so active in helping educate Idaho citizens has been valuable, and it's been really valuable to me. And I just want to say, one, that what's happened is it's really opened my eyes to the fact I thought Idaho would be like a Florida. I thought Idaho would be on the cutting edge. We'd be leaders out there in protecting its citizens at a state level. And what we're finding out is that's not the case. And so my biggest question always is, what can we do? And my understanding right now is just keep sending communications and emails to, are there specific folks that you would be more helpful, or just give us some guidance on right now, what is the most powerful thing that we as citizens can continue to do to help those handful of you that need to stay in office while we vote to get rid of the rest of them?
Being here today is awesome. It's good help. It's important to stay in contact with your representatives and your legislators. Now, over the weekend, I know that there was a string of emails, exchanges between citizens and representatives and senators. And because they were direct, they weren't a form letter or anything like that, it was a direct communication, there was movement. There was some movement. And so we don't live in an ivory tower, okay? I get up every morning and I eat my breakfast and get in my old car or truck and do whatever I need to do, just like everybody else. And so I think this notion that your representatives and your senators are somewhat a different class of people, that's wrong. That's wrong. And as a representative, I should never feel that way. And no one should. Because I am here because you asked me to come here and to be your voice in the decisions that are made in this building. So communicate, keep up with them. If they don't answer your emails, make a phone call. If they don't answer your phone calls and emails, then we need to be looking for other people that will respond to us when the time comes.
Thank you.
Next, yes.
Realistically, since we're looking at April now, time-wise, because I know about this time the legislature starts getting really antsy, they want to, money die and all that. What do you feel as far as the time? Is there enough time to get this thing done?
There's plenty enough time. I have seen bills go through the Ways and Means Committee in the House and be on the governor's desk in 48 hours. These timelines and these deadlines, they're basically arbitrary. They're a reason to get as much stuff in and done as we can according to the timelines, but I have yet to see any of them enforced. So there's plenty of time. It could be done, like I say, a couple of days, and it could be on the governor's desk if the legislature had the will to do it. Yes?
I'm under the impression that people are looking to pressure this issue in front of Brent Crane's business on Saturday in Nampa off 12th Street. I saw Shane Talks Politics at Twin Falls. They have a group from Eastern Idaho that's coming up to pressure this issue. I don't know if that's something that you have heard about or involved in, but a protest in regards to pushing this or moving this forward and pressuring getting a hearing in his committee, I think, through state affairs.
I haven't heard of it. I'm not involved in it. That's not usually something I participate in, to go to someone's business or to go to someone's home to protest like that. I'm not saying it's wrong. I'm not saying it's right. I'm just not involved in it, and this is the first I knew about it.
So I interject
Yeah.
for a second?
Please do.
I'm not gonna make a short joke, don't worry.
Oh, I know. See, you're supposed to stand down
Stand
off
down
the
there,
window.
yeah. So I want to make sure everybody that is watching is very aware of the politics of all of this, okay? Because there's definitely a lot of politics that are involved behind the scenes on what is happening. And quite frankly, I'm kind of flabbergasted at the wall that we have run into with this bill, because constitutional carry, which is what our organization was founded on, and the ability and your right to carry without government permission, much more controversial, so to speak, right? You know, all the blood in the streets and everybody's going to die because we're not requiring training, all that kind of stuff. And then we get to this year, when there's more gun control coming than we've ever had before. The Democrats have everything because the Republicans in Georgia screwed up and lost both of the Senate seats. And now they want to fight on a bill which, quite frankly, it should not be controversial. Even the Democrats should be on board with this.
John Gannon and Representative Mathias voted for it.
Yeah, in the print hearing, even the Democrats were like, sure, we can give this a public hearing. And so the roadblock, a lot of it is personality of politics, okay? So you'll notice she's a senator. You want to know why Don messed up on his presentation is because it should be a Senate bill. It's not a Senate bill, it's a House bill. And she tried for a long time, and I know because she has an entire timeline of everything that she tried to do to get this bill heard in the Senate, and now it's a House bill because Chairman Crane actually came to her very early on and said, hey, bring me the gun bills, bring me the gun bills. Well, we said, okay, well, she's a senator, we got to try and go through the Senate. Once we realized we were getting nowhere, we said, okay, let's go to Chairman Crane and have him hear the bill. Okay, and then as you guys know, we've already said this publicly, Chairman Crane eventually, the Friday when they recessed, came to us, had me and Senator Zito in her office and said, look, he's a co-sponsor of HB 300. But ultimately, Senator Lodge and him had a discussion, and she said, you know, she doesn't like me, okay? She doesn't like the Idaho Second Amendment line. She doesn't like you guys actually being involved and making these demands of your representatives. Some of them prefer you to just sit there and be quiet and not be involved, okay? But you guys you're actively involved. And that frustrates her. Our former chairman, Zach Brooks, ran against her, okay? So she chairs the committee that the gun bills have to go through. And so she's very upset at us. And so she's taking it out on the entire state. So now what you're seeing behind the scenes is we're pushing the Senate. We're saying the Senate is going to be the issue. Chairman Crane said, look, if she'll agree to it, we'll move it forward. But if she's not going to hear it on that side, then we don't really want to waste our time. I don't necessarily agree with that strategy, okay? But the reality is until Senator Lodge agrees to hear the bill, it might not go anywhere. And that's why we've been putting pressure on your senators to go convince her this is what the gun owners want. Put aside the petty politics, okay? Put aside the impersonal differences. Once the election's over, guess what? I will go work with any legislator if they're going to stand up and do the right thing. I don't care. Okay? I actually came out and supported one of Senator Lodge's bills this year that tightened up the ballot initiative issue. I supported it because I don't care. At the end of the day, I don't care how much you hate me. If I got ran over by a truck, they'd all be very happy. There'd be a very big party at the Capitol the next day, okay? I don't care. Get the job done. So yes, we've got to keep up the pressure.
So help me to understand a little bit, and this would be for the panel on the Constitution. I sometimes get a little bit confused when you've got the feds and they're trying to obviously enforce some laws down statewide that, so for instance, we're here saying, no, we want to protect our Second Amendment right, but there's an issue happening at the federal level. So this is where I sometimes get really, really confused is how much states have autonomy from the feds dictating. Is it solely money, or is there something in the Constitution? I would like to have a much better understanding of how states can become much more independent from the federal government and how that process is.
That's okay. Well, that's a lot. I'll have Don or Alex come up and maybe just touch on that briefly, and then also a concern that had come up from Representative Greg Cheney, who had actually taken time to at least come up with a response. I wanted them to also address that as well, so I'll have you guys address those issues.
That was a lot. But I'm going to simplify it, okay? And then Don, I know Don can expand on this. Greg, your screensaver came on, so there it is.
Well,
He has a question.
first, I hope nobody reports me to the state bar with my application betting that I confused a House bill with a Senate.
The simple answer is, and this is a takeaway about House Bill 300, okay? What the federal government protects in the Constitution is a floor, okay? What the feds are saying our Second Amendment protects is the minimum. States are able to protect us to a greater degree, and that's why I showed that slide on the Idaho Constitution. And that's why we want our legislature to put this in writing and say, we agree with this. And Don can give a more detailed, he probably has case law and all kinds of stuff to cite.
Well, on your question about how does federal law enforcement and state law enforcement get so intertangled, sometimes it's consensual. Sometimes the federal government holds out a lot of money that they take from us that goes to Washington, and then they offer it back to the states to say, if you help us create, I've seen these, I'm also a criminal defense lawyer, so by the way, folks, you're hearing from prosecutors and defense lawyers up here, so it's kind of a balanced presentation. But what they do is they form joint task forces where they have ATF agents or Treasury agents who go into an area of a state, or they have their offices in the state, and then they enlist the help of sheriffs, local sheriffs, and local police departments to enforce federal law. They do it to do undercover operations, they do it to execute warrants, and then they use the local law enforcement as witnesses in federal cases. They basically sort of deputize these people, make them temporary federal officers, what have you. The purpose of the previous bills is to stop that process and say, look, if the federal government is going to come into the state of Idaho to try and enforce federal laws, you're on your own. You cannot use federal resources to do that, okay? So that's part of what we have going on here.
Can't use state resources, right?
Can't use state resources, correct. So what our bill does is, rather than try and simply defy federal government, is we want to take an affirmative step and say, our Idaho Constitution has a broader umbrella of protection of the fundamental rights of our citizens than the state constitution. Now, that might not stop a warrant from being served by federal officers in the state of Idaho, but it does mean that the Idaho Attorney General might have to at least take a look at the case. It does mean that a citizen of the state of Idaho might have a defense and say, look, I'm exercising my Idaho constitutional rights. It does mean that the Idaho Attorney General can, rather than wait for a criminal case, file a civil action challenging these federal laws that impact on Idahoans' Second Amendment rights. We're not saying that, no, we're not going to comply with the National Firearms Act and you can make silencers outside of federal law here. We're not saying that people can own machine guns in violation of federal law here. But we are saying that there are some firearms that we believe constitute the necessary instruments for protecting the right to keep and bear arms and protecting property in Idaho. And we know that Idaho is different from downtown San Francisco, okay, where a handgun might be enough. But if you're out on a ranch in the middle of land out here, or ranch land in Idaho, you might need something more than just a handgun to protect your property and protect your life. Okay? Hope that answers your question.
Yes, that was very informative. Thank you. Thank you both.
Alex, did you have the?
Do you want me to read that question? Greg has asked me to, I'm distracted by the cute picture of your daughter, but I got.
That's actually Dove's daughter, but
Oh,
I'm sure he'll be happy.
okay. This was an email that came in from Representative Greg Cheney about House Bill, and this is being circulated, as I understand it, amongst other politicians and people, and it's a question that he had about why he would support House Bill 300. I fully support state refusal to participate in any federal infringement on our Second Amendment rights and believe the Attorney General's office should actively challenge any attempted federal action. Idaho Code 183315A, passed in 2010, and 183315B, passed in 2014, accomplish this as well. And I hope you see from the presentation today that that's not correct, or we at least have some issues that we're facing with that. My concern about House Bill 300 is that it creates new untested grounds for challenge, including narrowing definitions and constitutionally suspect provisions, such as the method of legislative intervention and affirmative instruction to the Attorney General. I want to hit that one right now because Senator Zito, wasn't some of that language pretty much plagiarized from another law that the legislature didn't have a problem with in the state of Idaho?
It's in Idaho code.
Okay.
The attorney.
So this right of intervention was something that we saw in another Idaho code section, and we thought, hey, this is great. We would like to have this in this Idaho code section.
The attorney general part, the right of intervention was in another piece of legislation.
Right, right.
And
The
even
right
if
of
it wasn't,
intervention.
why can't we do something new?
Well, we can. We can, but I'm just going to hit that one and we'll move on. Mike, and then he also says, I worry that legal challenges on these bases could undermine what we currently have, which we already have issues with what we currently have, and render the passage of H300 counterproductive. Okay, I'm going to, again, Don can expand on this, but what we have is somewhat novel. And I'm going to go back to what I said in the very beginning. Idaho's a leader in gun rights. We have a constitution that supports our right to keep and bear arms. And we do have to be a little creative here. We are leading this. However, from Don's presentation, as you saw, it's not like we just came up with this idea. This is something that's come out of the United States Supreme Court with respect to the First and the Fourth Amendment. And Justice Scalia mentioned that, oh, by the way, the Second Amendment is also a fundamental right. And so why wouldn't we apply the same legal analysis to the Second Amendment? So it may be novel to pair that same challenge that the state has a greater ability to protect us with respect to the Second Amendment because nobody's actually done it before. But when have we faced the kinds of gun control laws that we're facing right now in the United States of America?
Also, HB 300 is additive to the laws that we already have on the books. There's a provision that we didn't get to show you, but if you go back and read the bill, it specifically says we're leaving those untouched. We're neither subtracting for them, but we're simply adding to them. And also the idea that this instruction to the Attorney General is novel. It is not novel. It goes back to the Vermont habeas corpus law, where the citizens of the state of Vermont instructed their Attorney General and all attorneys working for the state of Vermont to work to try and mitigate or interpose itself between the fugitive slave laws, which were an abhorrence, okay, and the laws of the state of Vermont, which outlawed slavery, okay? So this idea that it's new to instruct the attorneys of this state to interpose themselves between the federal government and the citizens of the state of Idaho is not novel. It's been around for 200 years.
I just have a quick question. How does this differ conceptually from the sanctuary city and county laws that are such a bone of contention in my mind? Because they have enacted laws that allow them to ignore federal law, right?
Yeah. Excellent question. In fact, the United States Supreme Court, as recently as last term, upheld sanctuary laws in the state of California that frustrate federal policy with regard to immigration and naturalization issues. So again, the idea that that the state laws can interpose themselves between federal regulation and the individual citizens and residents of a state is not a new idea, and even it's not a new idea, it's an old idea, but it's also a new idea that has already been upheld by the United States Supreme Court. Now, there may be people who are on different sides of the issue with regard to sanctuary laws for Second Amendments and with sanctuary laws with regard to immigrants or people who are undocumented aliens in the country. But the principle is still the same, and that is that the state constitutions and the state laws and the state law mechanisms of the various states do have power when it comes to protecting their residents and citizens. Now, of course, there is a marked difference between the immigration issue and the Second Amendment issue. We actually have a Second Amendment in the Constitution. And of course, the immigration and naturalization laws are the duty of the Congress of the United States to pass, and they have apparently abdicated that responsibility, and we have the mess that we have going on now at our borders. But the principle is still the same. The state has the power to protect its residents and citizens from federal overreach, and so you're absolutely correct. This is modeled on the sanctuary laws that come out of California, New Mexico, Arizona, and what have you. So you're correct.
I hear you say SCOTUS supported those.
Yeah, there was a recent case, I believe it was California versus Trump or something like that, that upheld and now the sanctuary laws there were simply that there were to be no state resources spent on enforcing federal immigration laws, okay? What this actually ends up happening is there's some kind of active participation on the part of state law enforcement to assist people in evading federal law enforcement, but those are cases for other days and for the future, okay? This law does not authorize Idaho law enforcement to obstruct federal law. It simply says we will not assist.
Does the county and state regulations or laws that they pass for sanctuary status, be it for immigration or for Second Amendment, have the ability to intercede or stand up to state law? You know what I mean? Like, is that, because the state to federal mechanism is relevant or obvious, but like, do the cities and counties actually have the ability to leverage that? I know you said 1-1 in the
Right.
Supreme Court, but is there like a basis for that?
Well, somewhat of a complex answer. The thing is that states have no power to regulate immigration and naturalization. Okay, that's another case that came out of Arizona a couple of terms ago. Okay, so for a state to intercede on immigration issues is somewhat different than for a state to intercede or interpose itself on the right to keep and bear arms. The right to keep and bear arms is a fundamental right that is not dependent upon Congress promulgating rules for naturalization and immigration. I don't know if that answers your question.
Basically, like say a county or a state decided to say they want to do sanctuary status for Second Amendment, and they passed it locally on a local level, but then the state said, no, we don't agree with that. Is there that
Well, we're seeing that play itself out in the state of Virginia right now, because Virginia a few years ago passed a bunch of laws in its state house, and then there was a brush fire that ran across the state of Virginia with counties and cities passing sanctuary laws, with the state of Virginia actively opposing it. There's been no case on that yet.
Yeah, and additionally, I mean, a lot of cities and counties in Idaho here are passing resolutions. You'll notice that they're resolution stating that they support the Second Amendment. And the reason they can't really do an ordinance in Idaho is because of our preemption law, which prohibits them from passing anything regulating. And that prevents cities like Boise, with their mayor, from passing their own law that says, you know what, we're going to ban handguns here in the city of Boise. Our preemption law is stopping a lot of really bad stuff. And that's a little bit of what we're dealing with Sandpoint, is some preemption and then just constitutional violations.